2060.
SNP spokesman Chris Stevens.
Thank you, Madam Deputy Speaker. Can I first of all refer to my registered members' interest, my membership of Glasgow City Unison, and I'm a proud trade union member. And I too, like the Labour front bench, the irony has not escaped me of honourable and right honourable members last week securing workplace change by withdrawing their labour, bringing the country to a standstill, as the Minister said, as they did at one time, now wishing to stop others from doing so. And when I saw these regulations placed in the order paper, I asked myself this question: was that for the trade unions or was it for the Tories? Because the question that I have is, in Operation Save Big Dog last week, was a consideration given to hiring agency ministers? Because that's the level that we were going to, Madam Deputy Speaker. But what is wrong with these regulations, of course, is that the government tried them before, and they tried them during the trade union bill. And if indeed there were honourable members on the government side who suggested to the government that they shouldn't go down this line. And the reason they shouldn't have gone down this line then, and why they didn't then, and why they shouldn't now, is because of the evidence of agencies themselves who do not support this legislation. And there's no consultation in this. It also interferes with devolution, as we heard from a number of speakers so far, in terms of trying to end the Wales Trade Union Act. It also interferes with the legislation and approach in Scotland of using the Fair Work model. And once again, we see the government running roughshod over devolution. It's also based on fanciful notions. Now, the Minister didn't use this phrase, but I've heard this phrase over the last couple of weeks of trade union bosses. Well, trade unions aren't the bosses, actually, they are the representatives. And what has been suggested to us, in some of the contributions we hear, that it's all the fault of the trade unions that these disputes take place, and not those poor, downtrodden, six-figure salary executives who are not engaging in that. And there's no such thing as a union baron, can I say to the honourable gentleman. He's one of the members who last week withdrew his labour, was hitting the cobblestones, and now, given his rhetoric tonight, wishes to stop others from doing so. But there are a number of reasons as well that I want to add to, Madam Deputy Speaker, and that's the likely breach of international law. The use of agency workers to replace striking workers would violate trade union members' rights to strike, which is safeguarded by ILO Convention 87, Article 3, the European Social Charter 1961, Article 6(4), and Article 11 of the European Convention of Human Rights. Indeed, the International Labour Organisation's Freedom Association Committee has said the hiring of workers to break a strike in a sector which cannot be regarded as an essential sector in the strictest sense of the term constitutes a serious violation of freedom of association. And on the 16th of June, the Institute of Employment Rights published an article by the great Professor Keith Ewing, Professor of Public Law at King's College London, who discussed this particular convention and indeed has referred to the government's own act, the EU-UK Trade and Cooperation Agreement, which is given an effect into UK law via the European Union Future Relationships Act 2020. It suggested that this statutory instrument would repeal Regulation 7 would be and may be unlawful. It is at least arguable that the pre-existing powers are constrained by the 2020 Act Section 29 so that they cannot be used in a way that will violate the Trade and Cooperation Agreement and the obligations thereunder. And if this argument is correct, the government is constrained by its own hand from legislating to revoke Regulation 7 into secondary legislation. There will also be the negative impact on agency workers. Allowing the deployment of agency workers would put those workers in a horrible position. They would have to choose between crossing a picket line and turning down an assignment with the prospect that they will be denied future work by the agency. Many agency workers, such as supply teachers or bank nurses, will be trade union members themselves. Under the UK's weak employment laws, agency workers are not protected from suffering a detriment if they refuse an assignment because they do not wish to replace striking workers. And there will also be a negative impact on the agencies themselves. The removal of the ban on the supply of agency workers would mean that employment businesses were forced to become involved in industrial disputes which are not of their making. That's why agencies themselves oppose the proposals, as others have said. In a joint statement with the Trade Union Congress, the Recruitment and Employment Confederation urged the Government to leave the current ban in place as a key element of a sustainable national employment relations framework. And part of the reason for that, Madam Deputy Speaker, is that there's a realisation between employers and trade unions that disputes come to an end. I mean, disputes come to an end, and then has to be a discussion about how you move forward from that dispute and how you rebuild industrial relations. As Neil Carberry, the Chief Executive of REC, stated, the Government's proposals will not work. Agency staff have a choice of roles and are highly unlikely to choose to cross picket lines. And there is the safety issues. The health and safety of agency workers and the potential act of this on public safety is a serious concern to trade unions. Studies suggest that temporary agency workers are exposed to more hazards and have higher rates of workplace injuries and ill health. A simple research of the Health and Safety Executive's prosecutions over the last 5 years show a litany of employer failures in terms of a lack of training of agency workers, lack of access to protective equipment, a lack of supervision and monitoring of agency workers to ensure they understand and are following risk assessments and safe systems of work. These failures have resulted, sadly, in fatal or life-changing injuries to the agency worker. And we also know that those who work as agency workers, that their health and safety is often overlooked. When the work involves delivering a public service, this can present risks to the service user or engender wider public safety. The Health and Safety Executive and other safety bodies broadly agree that the components of a positive safety culture and successful health and safety management leading to fewer incidents include good communication, competence training and induction, good team working, ability to raise concerns with no detriment, and good worker involvement. And the hiring of agency workers to try and disrupt industrial action would not do that. There's also the concerns about public safety, because under Section 3 of the Health and Safety at Work Act, employers taking on agency workers are responsible for their safety and the safety of the public. The agency placing the worker who has responsibility, and we suggest that failures in safety occur due to that lack of communication and consultation between the two duty holders, with the safety of the agency worker falling through the gaps. This is borne out again and supported by reports by the Health and Safety Executive, which found that around half of the recruitment agencies surveyed did not have measures in place to ensure that they were fulfilling their legal obligations. And the proposal, frankly, Madam Deputy Speaker, is not practical. There are, as has been stated earlier by honourable members, there are currently 1.3 million vacancies in the UK, a record high. Data shows that the number of candidates available to fill roles has been falling at record pace for months. And in this tight labour market, agency workers are in high demand and can pick and choose the jobs they take. Are they seriously going to take a job where they have to cross a picket line in order to get a shift? Or will they pick another one? Well, perhaps the honourable gentleman would be, but I have to say he is perhaps a unique case. Agency workers are very unlikely. I'll give way to honourable friend.
Does he share my concern that many on the government benches would turn the clock back to the days of the bond, where we had indentured labour, and my grandfather's father was paid a modest sum to be as a bond to be an indentured labour in the mines, and it was illegal to go on strike. And if they did go on strike for better terms and conditions, they were evicted from their homes. It's a disgrace that members opposite are trying to turn the clock back to those days.
Well, I thank the honourable gentleman on that. And of course, the government did introduce the Master and Servants Acts 1823, and I could go on from there, Madam Deputy Speaker, but I won't. But I think that gives... Well, it was about what implements could be used to discipline a worker. The honourable gentleman might want to know that. He might want to reflect on that, because the whips might have did something to him last week when he was taking his industrial action. So, but can I say, Madam Deputy Speaker, the honourable gentleman was correct, but I just don't think they understand what happens in the workplace.
Yeah, hear.
That's the issue here. They don't understand. They think that agencies will come in and replace these striking workers. It's just not going to happen, because they will not do that. And an agency staff person who has the choice of crossing a picket line to get a shift or not crossing a picket line and getting a shift somewhere else is going to choose the latter option and not the former option. And that's just the reality of the situation. I'll give way, of course.
I'm grateful to the honourable member who's making an excellent speech, but also employers won't want to hire these agencies workers into these safety critical industries because they know the liability is going to sit with them when the injuries and the accidents occur, and often these roles are in very safety critical places as well. So these workers are just simply irreplaceable.
Well, that's absolutely right, and you know, there's this suggestion that they could bust the rail dispute at the moment with hiring agency workers. Where are these unemployed signalmen, Madam Deputy Speaker, who are sitting in their homes unemployed, saying, I can't wait for the railway workers to get out and strike so I can get my shift? It just isn't there. These people don't exist, and therefore this is completely wrong-headed and is completely and utterly impractical. In the gig economy, so-called key workers fighting for better employment terms and pay seem to be expendable under a Tory government who don't care. And as we've heard, where is this employment bill they've been promising us since 2015? And another thing I would say, Madam Deputy Speaker, which I forgot to say at the beginning of my remarks, the Prime Minister committed last week, after his resignation, that he would not introduce legislation that was not in the Government manifesto and would not introduce controversial legislation. Well, by any measure, Madam Deputy Speaker, this is controversial legislation, and crucially was not in the Conservative Party manifesto and should not be introduced. So I've got a couple of questions for the Minister. What assessment has the Secretary of State made of the compatibility of the Conduct of Employment Agencies and Employment Businesses Amendment Regulations 2022, as we're discussing today, with the Human Rights Act, the Trade and Cooperation Agreement with the European Union, the UK's commitment to ILO's fundamental conventions, including Convention 87, Article 3. We've heard about the impact assessment, but what consultations has the Government had with the rail industry employers, rail industry unions and rail industry regulators, including the Rail Safety and Standards Board, regarding the risk assessment in relation to the use of agency workers in safety-critical parts of the rail industry? And what consultations has the Government had with devolved administrations, local authorities, health boards and other public services? I'm guessing they haven't, because if they did, they'd be told that these proposals were not workable. And what consultations has the Government had with employment agencies themselves? Because we've already heard that they do not support this legislation. I'm going to certainly the SNP benches will be opposing the government's SI. Will be supporting the Labour prayer, because as my friend in the Labour front bench, good unison comrade that she is, and I've known her for 15 years, and I know that the trade union is proud of her work in here, as well as other honourable members. A full impact assessment is not being produced for this instrument. It's no significant impact on the private, voluntary or public sector is foreseen. It's just madness. Fining trade unions for pursuing strike actions deemed as unlawful is a deliberate Tory attack to undermine trade union members and working people from pursuing their aims. And instead, the Transport Minister should be negotiating with the trade unions, sitting down with them and seeing if he can help resolve this dispute. And so, Madam Deputy Speaker, I will draw my remarks to a close by saying that once again it's quite incredible how this government does not understand working people, how modern trade unionised workplaces operate and work, and therefore these the statutory instrument they propose tonight should be placed in the bin.
Here. Thank you. I'm going to impose a time limit of 4 minutes.